Bad faith, lack of honesty, intentional dishonest action. Bad faith refusal to pay insurance claim. An action against an insurer alleging that the insurer acted without reason and fair dealing in refusing to pay an insured's claim. Bail, security required by the court to guarantee the defendant's presence at trial. Bail bond, a contract between a licensed surety and the defendant for the payment of bail. Bailee, one who receives personal property under a bailment. Bailiff, a court attendant whose primary duties include keeping order in the courtroom and attending to the jury. Bailment, an express or implied contract for the storage or safekeeping of personal property. Bailer, one who delivers personal property under a bailment. Bank, the place where a court regularly conducts judicial business. Barrister, an English trial lawyer. Compare solicitor. Bastard, an illegitimate person, one born out of wedlock. Batson hearing, a legal proceeding that requires the trial court to determine whether the exercise of a peremptory strike was purposefully discriminatory. Battery, first, civil, any unlawful and willful use of force or violence upon the person of another. Second, criminal. Simple and aggravated assault are defined under Mississippi Code and Section 97-3-7. Bench warrant, process issued by the court itself for the arrest of someone. Bequeath, to give personal property to another by a will. Bequest, a gift of personal property by a will. A legacy. Best evidence rule, primary proof as distinguished from secondary, original as distinguished from a copy. Applied only to documents, never to testimony. Beyond a reasonable doubt, proof to the exclusion of every reasonable hypothesis except that of guilt. Bifurcated, Latin, two-pronged, a trial or hearing separated into distinct phases, usually as to issues of guilt and punishment to safeguard against undue prejudice or otherwise ensure justice. Bill of Equity, the initial pleading in former Mississippi Chancery practice. See Complaint. Bill of Exceptions, first, an appellate record especially of a judgment or decision of municipal authorities. Second, a formal statement of objections to be included in the record. Binding instruction, directions to the jury that if it finds certain conditions to be true, it must find for the plaintiff or the defendant as the case may be. Bind over, to hold an accused for action by the grand jury after a finding at a preliminary hearing that there is probable cause to believe that the accused committed a crime. Blog, a website where the author writes about subjects such as news, politics, or the legal system. It is displayed in reverse chronological order. Bona fide, Latin, in good faith, genuine. Boundary, the physical limits of a parcel of real estate as described in a deed, a property line. Boundary line agreement, an agreement between adjacent landowners fixing the property line. Breach of contract, a failure without legal excuse to perform any promise which forms the whole or part of a contract. Brief, a document presented to the court that contains facts and law supporting a client's position. Burglary, breaking, any act of force, however slight, used to unlawfully enter a structure. Burglary, entering, the act of making one's way into a structure. Burden of proof, the standard of requisite proof necessary to prevail on the merits of the case. Criminal law requires proof beyond a reasonable doubt. Civil law ordinarily requires proof by the preponderance of the evidence. Burglary, breaking and entering the dwelling house or the inner door of such dwelling house of another, whether armed with a deadly weapon or not, and whether there shall be at the time some human being in such dwelling house or not, with intent to commit some crime therein.